Good afternoon. My name is Alena Shautsova. I'm an employment attorney from New York. In today's video, I would like to talk to you and tell you about federal lawsuit in connection with employment discrimination claim. What it is, what it requires, what can you expect from that federal litigation? Unfortunately, it is the reality that very often your employer does not want to see your side of the things, do not want to resolve the situation that you encountered, the situation that you may have complained peacefully, and you have to bring a lawsuit against your employer. So before you do that, you need to know what you can expect from this adventure. So first of all, to go to federal court, you will need to comply with administrative prerequisites for the federal lawsuit, which is a complaint, usually with EEOC, or Equal Employment Opportunity Commission. Okay, it's a necessary step. You will have to file that complaint. Sometimes it takes a very long time to receive that right to sue letter. Sometimes it comes fairly quickly, depends on the details of your case, but you must receive a right to sue letter before you can sue your employer in federal court. Right to sue letter may state that there was a probable cause found in your charge is your complaint, your description of what happened. It may say that there was no probable cause found. It may say that the EEOC does not see facts to make a decision as to whether or not there is a probable cause. Do not worry about it. We have helped many clients whose EEOC right to sue letter stated that there was no probable cause, and yet they were able to recover after the federal lawsuit for their damages. Okay, so the first step is to receive that right to sue letter. Once you have the right to sue letter, all right, you have 90 days, only 90 days to file your federal lawsuit. Federal lawsuit starts with a complaint. It's a concise explanation as to what happened. You do not have to put every detail as to what happened, but it has to have it has to give a fair notice of what is it that you're complaining about to the other side. The other side usually has a pretty good idea, but because the way the law is structured, complaint is a legal document and has to meet certain legal criteria to qualify as such, and for it not to be defeated right after it was filed, okay, for insufficiency. So you file complaint, then you have to serve your employer. You have to hire a process server, so this complaint will be legally delivered to your employer. In other words, you cannot just, mail it to them. It has to be legally delivered according to the law of the state where the employer is located. Very important. Then, if everything goes well, there will be discovery process. It's when you are allowed to ask for information and documents supporting your claim from the employer, but the employer is allowed to do the same from you. One of the important aspects or kinds, particularities of the discovery process is depositions. Depositions is when your attorney can depose or ask questions on the record. Questions, you're going to be deposing the witnesses, your employer. Sometimes it's a owner of the company or manager or the person who specifically harmed you, okay, caused damages to you. Maybe it's the person who made the decision to terminate you. Maybe it's somebody who you state he or she was harassing you, okay? Employer can do the same. They can ask questions. They can ask you questions under oath. It's very important to prepare well for your depositions. And of course, you will need the help of a qualified attorney to defend you during the depositions. It's an important aspect of it. After discovery, usually, if everything goes well, there may be motion practice. Motion practice is when one of the sides, you or defendants, state that We already proved some of our portion of our case. It's a legal basis for the liability. Or that's what you may say, or the other side may say, you guys don't have sufficient facts to support the liability in the case. It's a common practice, motion summary judgment, for example. And if everything goes well, you're going to win summary judgment if it's filed against you, meaning that your claim is going to survive to the final step, the trial. So that's how long it takes to get to the trial, when you're actually going to see the jurors. Sometimes it takes about a couple of years, okay? Sometimes during this process there are extra steps like mediation, court ordered mediation. For example, it's practiced in Southern District of New York. All employment discrimination cases are automatically referred to the mediation program. Sometimes it's a private mediation. Your attorney and the other side's attorney believe that they may resolve the case with the help of a qualified mediator. From my experience, mediators can be very effective. It saves, in the long run, it saves time and money, helps to identify issues in the cases and resolve the case effectively. But this is what a federal lawsuit would look like. Remember that federal lawsuits are public, okay? Meaning that all members of the public, meaning everyone, may actually find them and find most of the filings, unless filings were done under seal online. Okay, very important. So I hope this video is helpful, and please, if you have questions about your employment discrimination case, call us at 917-885-2261. Thank you.